I have prepared a written judgment. It is about 258 pages, which is quite lengthy. As is now the norm and practice in criminal matters, I am reading out into the record an executive summary. The purposes of the summary is not to set out the judgment, but it's exactly that. It's an executive summary. It is 38 pages, and a full and detailed evaluation of the evidence would appear from the written judgment. The written judgment is signed by me and shall be considered as having been delivered as and when I conclude this executive summary. I will read now into the record my executive summary, and copies of the judgment will be available to counsel upon my adjournment of court. On a winter Sunday morning in July 2016, the shocking news of the death of a guest at Spear Hotel rippled through our community and gripped news coverage around the globe. The upmarket hotel, set in the picturesque Stellenbosch region of the Western Cape, also known as the Cape Winelands, posed a stark contrast to the half-naked body of Jason Rohde, dead on the bathroom floor of room 221. A life most certainly interrupted and cut short in her prime at the tender age of 47. She was the mother of 3 daughters. She was also the wife of Jason Rohde, a successful businessman, the South African Group CEO of Lou Giffen Sotheby's International at the time. The Realty Group's annual conference was held at Spear on the weekend of 22 to 24 July 2016. It was, however, a fact that many had only come to realize afterwards. Spear was also the setting of the final scene of a love triangle which had formed some months before. Jason and Susan lived in Bryanston, Johannesburg. They were married for 24 years with 3 adolescent daughters when 2 weeks after Valentine's Day in February 2016, Susan discovered a surprise card left for Jason in his suitcase by his mistress, Jolene. The card said it all. Jason had been having an affair. Susan confronted her husband without delay. She locked them up in their ensuite bathroom, isolating them from their children, interrogated what was apparent from the card to be proof of a love affair. She instructed Jason to call his mistress on speaker and break off the affair in her presence. Jason obliged. This marked the first episode of what kicked off months of a myriad of emotions in this love triangle. Susan's ill-fated discovery was followed with months of harrowing trauma. The emotional hallmarks of infidelity entwined itself like creeping ivy into the lives of those affected. Betrayal, suspicion, passion, sex, frustration, anxiety, anger, and humiliation, to mention but a few, took its inevitable shape. Ever the perfectionist, Susan struggled in silence. She wanted to keep the appearance that all was well, but beneath her exterior, she was struggling to cope with her emotions. She felt her life had been turned upside down. Jolene Altersky, an estate agent with Sotheby's, would be attending the Spear conference. Susan, wise to this fact, insisted that she would escort Jason during this weekend at Spear. Susan wanted to make sure that Jolene would see them together and realize that there is no place for her in their marriage. Her husband had assured her the affair was over. he expressed his commitment to the marriage. Susan was still niggled with suspicions, but she was desperate to make sure that this marriage continued. This weekend, she was going to openly triumph over her nemesis and prove to all that would see them that they were indeed the picture-perfect couple. A united front is what she called it. Jason stormed out of marriage counseling, infuriated by Susan's insistence to attend at speed. From Botox injections to clothing on Apro, Susan was ready for the weekend. She was going to look her best for the occasion. She fitted on outfits. She was going to make absolutely sure to leave nothing unattended in ensuring that she looked her best. She traveled to Cape Town in time for the conference. This would be her last journey. Jason delivered the opening speech under the watchful eye of his wife. Desperate to conceal the affair from her, he avoided looking into Jolene's direction at all costs. Later, Jason messaged Jolene, and I quote, "Cause I am frustrated. I can't be with you, who I want. You still love me? Question mark. Next message. All I can think of is you. I want to scream with frustration. I don't want anything more in my life than to be with you. Next message. I absolutely hate it. I just want it to end. Next message. Having you close is driving me crazy. Sue is driving me nuts. She follows me around like a fucking shadow. Jolene replied reassuringly, my penguin forever. The following morning, hours after this message was sent, Susan was dead. In the hours before her death, Jason and Susan had returned to room 221 from their gala dinner. Susan wanted to settle down with her husband and got undressed. Jason, however, wanted to be with his mistress. He sneaked into the bathroom to send his lover a message when Susan caught him in the act. Her suspicions that the affair was not over had proven true. Tempers soared as it became clear that Jason's game was over. He wanted to get out and go to his lover. Their argument soon became physical, with Susan wanting to restrain Jason from leaving the room and Jason wanting to get to his lover. She did not give up the fight. She scurried behind him from one room to the next. Annoyed, fearful, and frustrated that Susan would confront his lover, Jason eventually acceded to his wife's command. This would be the last time that she would be seen alive outside of room 221. Jason said that Susan took her own life as a final response to his persistent love affair with Jolene. Susan had been depressed and suicidal, but the humiliation and shock that the affair had been ongoing and that he wanted to end their marriage had clearly been too much for her to bear. She went to the bathroom that morning, closed the door. He fell back to sleep, and unbeknownst to him, tragedy struck. From the towel hook behind the bathroom door, his wife hanged herself with a cord of her hair-curling iron. The state, by contrast, alleges that Jason murdered Susan, then staged her death as a suicide. He was brought before the court as an accused and charged. This is the judgment of the trial which followed. The accused pleaded not guilty and offered a plea explanation admitting to the affair, that his marriage with the deceased took strain when she discovered his infidelity, and that she had attended the speed conference against his wishes. They had a physical fight in the early hours of Sunday morning and claimed that the deceased had committed suicide. He denied that he killed her or that he staged her death as a suicide. The crucial question before the court is very simply, in the absence of any suggestion of an intruder, did the deceased take her own life, or did the accused murder her? Was it suicide or homicide? The State called a number of lay witnesses, Messrs. Desmond Daniels and Mark Thompson. They were of the first persons to arrive on the scene. And then there was Peter Norton, the deceased brother-in-law, who arrived later. There was Mr. Mabeta, a security official at Spear. There was Mark Holmes, the deceased brother. There's Mr. Joep Skoof, the general manager at the Spear Hotel. And there's also Ms. Farah Amirmia, a colleague of the accused, who had been present at the conference. Also called were a number of expert witnesses, Drs. Akmal Kutsia Khan and Deirdre Abrams. They were the state pathologists who had respectively conducted and overseen the initial autopsy. Warrant Officers Engelbrecht and van Niekerk in relation to cell phone data and communication. Jane Newcomb, the deceased treating psychologist. Carol Nader, the marriage counselor of the deceased and the accused. Then there was Dr. Lisa Marie Steenkamp, the deceased general practitioner. There was also Captain Marius Joubert, a crime scene expert and bloodstain pattern analyst regarding DNA samples collected from the scene, as well as Lieutenant Colonel Charlene Otto. She testified regarding DNA analysis of the bloodstains. There was also Colonel Daniel Pullman regarding the engineering aspects relating to the bathroom door and the curling iron cord. There was Captain May September and Constable Fernandez regarding the events at the scene on the day, and Sergeants Stephen Adams and Marlon Apollos, who were involved in an investigative capacity and had conducted several witness interviews. The accused testified on his own behalf, and his legal team further called 3 expert witnesses. Dr. Perumal, a forensic pathologist, who conducted a second autopsy at the instance of the accused. Dr. Larissa Paneri-Peter, a forensic specialist psychiatrist, who had conducted a psychological autopsy of the deceased and a psychiatric assessment of the accused, as well as Dr. Isaac Loftus, a forensic and anatomical pathologist who testified with regard to the autopsy findings made in this matter. Also called was Mr. Brandon Miller, a colleague of the deceased, also in attendance at the conference. In my judgment, I set out a detailed summary of the testimony of the witnesses called by the state and the defense. Same appear from pages 10 to 161 thereof. I deal further with the applicable legal principles relating to expert evidence, the history of expert evidence in our law, as well as the guiding principles relevant thereto. I also deal with the issue of psychological autopsies, the aspect of judicial independence in the face of expert evidence, and aspects relating to medical privilege and the applicable legal principles. A critical evaluation of the evidence of the various lay, professional and expert witnesses for the state are as set out from pages 173 to 192. I considered with particular reference to the evidence of Thompson and Daniels as single witnesses and the applicable cautionary rules and case law which this court must take into account in its evaluation thereof. A critical evaluation of the evidence of the accused and the 3 expert witnesses for the defense appears as set out at pages 192 to 230. A discussion of the evidence holistically viewed with the probabilities, improbabilities, strengths, weaknesses, merits and demerits of the case, and the reasonable inference that can be drawn from circumstantial evidence follows from page 230 to 244. For the purposes of the summary, I briefly deal with the evidence of certain witnesses. This is, I remind, a very brief summary. It is not exhaustive of the evidence that was led and as set out in my written judgment. The testimony of Daniels was briefly that on the morning of the 24th, that is the morning that the deceased died, He responded to a call from the control room regarding a bathroom door that could not open. He proceeded to room 221. After he knocked, the accused opened and informed him that the bathroom door was locked from the inside. He was not informed that there was someone inside the bathroom. He unlocked the door using a screwdriver, and he opened the door easily, he said, as it offered no resistance. Once he had opened the door, he saw a person's legs from the calves down. The accused brushed past him into the bathroom. After a few seconds, the accused beckoned him into the bathroom. He was waiting outside. He then entered and saw the deceased being held up in the arms by the accused, and she was facing towards the witness. He asked Daniels to remove the cord from around her neck. The deceased, he said, was naked and she was not breathing. The cord was not tight around her neck, and so he removed it easily. He stepped out of the bathroom, left the cord dangling from behind the towel hook onto the floor, and from the bedroom he contacted the control room for assistance. Daniels, I may add at this point, was subjected to lengthy, hostile, and vigorous cross-examination, often on matters also irrelevant to the issues before this court. Mr. Mark Thompson had been a colleague of the accused at Sotheby's International Realty and had known both him and the deceased for a number of years. At 8:30, or round about that time, on Sunday the 24th of July, he had been conversing with some of the other attendees at the breakfast venue when he heard that something had happened at the hotel. He rushed to the scene, and upon entering the room, he saw the deceased's naked body on the bathroom floor. The accused, who was seated next to her, asked for his help. Though he, that is Thompson, had never before attempted or did CPR on anybody, he proceeded with chest compressions and resuscitation. He soon realized that the deceased was dead. Her body was cold, her lips were blue, and her skin porcelain white, he said. For about 30 to 45 minutes, he attempted to resuscitate her, during which time the accused blew into her mouth once and then sat down. During his attempts, he had to wipe away blood from the nose of the deceased. Through his horror and discomfort, he noted some things which made him question the notion of the deceased having committed suicide. When he exhausted himself in his CPR attempts, he sat down next to the accused and held him. He had reached out, he said, to the accused subsequent to the incident, but his attempts were rebuffed. He had also received trauma counseling, which helped him cope with the event, and in this way he explained why certain things had stood out for him. His evidence gives the court an opportunity to sit like a fly on the wall, as the proverbial statement would be, and through his evidence, the court is able to understand why, so early in the matter, there was a suggestion that the deceased had not committed suicide. Mr. Mark Holmes, resident in Australia, testified about events after the news broke of his sister's death. He also gave an account of his sister's character and personality and how she dealt with conflict in her life. Through his evidence, the court was able to gather that the deceased was not scarred by her father's infidelity some 16 years ago, and that she had a positive input in her parents' marital counseling. Peter Norton is the deceased brother-in-law. Upon learning of the deceased's death, he immediately went to Spear, where he met with the accused and other relatives, including the deceased's father, Mr. Neville Holmes. Mr. Holmes questioned the deceased as to what had happened. Mr. Holmes also asked to see the accused's hands, where Mr. Norton said he also looked and he did not notice any marks or injuries on the deceased's hands. He also read out the statement by the accused in his presence at Spear, in which the accused stated that himself and the deceased had a fight and that she had fallen outside. Norton testified the accused arrived late at the funeral of the deceased and had not stayed afterwards for tea. He indicated that the family viewed the deceased with compassion mixed with suspicion at the funeral. Mr. Mabeta was on duty as a security guard at Speed on the 23rd of July from 6 o'clock that evening until the following day. While patrolling, he saw the deceased and the accused rushing past him. They looked as if they were arguing, with the accused pushing the deceased. She was barefooted and in a white gown. Mr. Joop Skoof has been the general manager at Speed Hotel since 2013. He testified as to how the hotel dealt with the incident and the support that was given to affected staff members. He had attended court with Daniels, who was an employee of the hotel where he is a manager, in order to provide what he called moral support. He also testified that he had not discussed Daniels' testimony with either the police or the prosecuting authority. He denied having coached Daniels and that he had merely seen to his comfort and that they had not discussed his testimony during the lunch adjournment. The hotel protocol, he indicated, was that if a door could not open, the staff member would be expected to assist the guest so that the door could get opened, and the staff member would be required to open the door. But if a door is simply locked, the staff member would merely have to unlock it. Ms. Farah Amir Mia and Mr. Brendan Miller, they were each respectively called by the state and the defense. They are employees of Sotheby's, and they had attended the conference at Spear. On the morning of Sunday, the 24th of July, they had been having drinks with Jolene in the room of Miller when the accused walked in and sat down on the edge of the bed. The deceased entered the room. She was wearing a white gown, and after beckoning the accused, sounding agitated and stern, they left together. She could hear them arguing outside. Mr. Miller's testimony largely confirmed the testimony of this witness. Captain September and Fernandez are members of the South African Police Services. They were the police attending to the scene at the day after having been called by their control to attend there too. Fernandez indicated that he took a first statement from Daniels. He took it on the car bonnet in the parking area of the estate on the Sunday. And September, who indicated that he was in control of the scene, confirmed that the matter had initially been treated as an inquest under docket number 83/07/2016. Sergeant Stephen Adams is a detective with the South African Police Services. He investigated the matter alongside Sergeant Molinopolis. Adams testified, amongst other things, that he prepared Daniels as a witness for the court, but he denied coaching him. He emphasized that Mr. Daniels was unsophisticated in court proceedings, had never before appeared in court, and he assisted Mr. Daniels in preparation as to the procedures in court. Adams also testified that the domestic employee of the accused and the deceased had not, during her long employment with them, ever noted or suspected any domestic violence perpetrated by the accused against the deceased. Sergeant Marlon Apollos was the other investigating officer in this matter. His task was to oversee the investigation done at the scene. His investigation started outside of the bedroom. He looked for broken windows or doors or anything that would account for being out of the ordinary, which he did not find. It was not placed into dispute that the deceased and the accused were alone in room 221 in the early hours of Sunday morning until Daniels arrived on the scene. Apollos further testified he found a burnt note as well as a letter in the laptop bag, from which contents indicated to him that the accused had been having an extramarital affair. He also found other personal items and a laptop. He did not find a suicide note or a diary. After the autopsy on the 26th of July, Dr. Khan informed him that the cause of death was, in his view, murder, and he opened a murder docket. He then met with Daniels and Thompson on the following day, which was the Wednesday. The accused was informed on the Thursday, when he came down to Cape Town, that the investigation into her death has been turned into a murder investigation, and that the accused was a suspect, and that he would be charged accordingly. He stated that the accused had been arrested on the 23rd of August after receiving information which concerned him that the accused might be a flight risk. Colonel Poolman, who heads the engineering subsection of the Forensic Science Laboratory, testified that he had entertained some doubts as to how the deceased could have hanged herself with a curling iron cord. He inspected the scene of the incident. His testimony related to the functioning of the lock and that it could open and close from the outside with teaspoons and coins, but not with his fingers. He had also done certain tensile tests on the cord to determine whether it had stretched, whether there was anything wrong with the cord, and at what point the cord would have failed. Warrant Officer Jeremias Engelbrecht assisted with data extraction from cell phones. According to the data collected, Jolene had sent a WhatsApp to the deceased at 5:50, and the deceased had sent messages to Jolene at 07:02 that morning, and again at 07:06, which was the last communication from the deceased's phone. The last message between the accused and Jolene, she indicated that weekend, was at around 10:45 on the 23rd. Warrant Officer Annemarie van Niekerk did an analysis of the cell phone records and call logs from Spier Hotel. She established the timeline of the communication between the accused, the deceased, and Jolene on the weekend at Spier, which showed extensive calls and messages passing between various parties. The records also indicated messages sent between the deceased and her psychologist, Jane Newcomb. The content of the messages were handed in as exhibits before this court. Captain Marius Hubert has 24 years' experience as a crime scene investigator and is an expert on crime scene and bloodstain pattern analysis. On attending the scene, he had been informed by Sergeant Apollos and Constable Mbongo that they believed the bloodstains at the scene to be contemporaneous with the incident. His DNA report noted 2 donors of the blood found at the scene. That was the blood of the deceased and the blood of the accused. He had noted a contact transfer of the accused blood on the bathroom floor, as well as the blood stains belonging to the accused on other items in the bedroom, which included the duvet cover and pillowcases. Blood of the deceased on the bed sheet was consistent with her lying in bed with a bleeding toe. She had been lying on the right side of the bed, not on the left. This he could interpret from the blood stains, which was only on the right side of the bed, together with the narrative that she had cut her toe whilst walking outside of the hotel room when she returned to the hotel in the early hours of Sunday morning. The abrasion on the left eye of the deceased was consistent with stains on the pillow. However, I may add that this is the pillow on the other side of the bed. These stains also appear on the pillow with 2 mascara marks and blood from the deceased's right eyelid. Her blood was also found on the duvet cover. Her blood was also found on another pillow on the floor next to the side of the bed. The accused would have had to have a small injury, such as a cut, for his blood to have been deposited in the bedroom and the bathroom, he testified. His blood on the bathroom floor would have resulted from the accused coming into contact with an object which transferred onto the floor. The blood in the bed likely did not come from the deceased having a bleeding nose, as this would have resulted in a blood drip betrayal pattern. He also confirmed that the bloodstains were contemporaneous, meaning that the bloodstains happened approximately at the same time. Lieutenant Charlene Otto, also employed with the Forensic Sciences Laboratory, did a DNA analysis of samples taken from the scene and gave an account of her findings. She also stated that blood ordinarily dries within approximately 30 minutes. Dr. Lisa Marie Steenkamp had been the deceased general practitioner since February 2014, primarily for the purposes of Botox injections, which is a form of cosmetic treatment. In the months before her death, she saw the deceased for cosmetic treatment. She also prescribed medication for sleeping problems, to relieve anxiety, as well as heartburn. She indicated that during June, there was a consultation when the deceased was tearful, and she indicated to the doctor, without further details, that she was suffering some marital problems. The deceased consultation in July, which was 9 days before the speed event, was for the administration of Botox. She indicated that she also used this consultation to follow up on the medication she had previously prescribed. She said the deceased looked happier compared to an earlier visit where she was tearful, and told the doctor that she was joining her husband to speed the following weekend. She also asked Steenkamp to make her pretty. Jane Newcomb had been the deceased treating psychologist who had seen her for a total of 8 sessions commencing in May 2016. The deceased had stated her reason for seeking therapy as being the accused's affair and her inability to cope with the emotional turmoil it caused. The deceased had denied any violence in the marriage, but she did admit that they had fierce arguments. She described the accused as being anxious. She described the deceased as being anxious and suffering from turmoil, which she, in her view, normally associate with that of betrayed spouses and the normal experiences which they would experience. Her husband's extramarital affair, she said, had caused the deceased emotional pain, but she did not experience the deceased as being suicidal. She said, while the deceased was anxious, she was not depressed. The deceased contacted her from Speed on the Friday. From their contact, she did not in any way perceive her patient to be in despair or depressed. Newcomb stated that the deceased had a number of protective factors in her life that militated against her being at risk of suicide, and that she had progressed well with therapeutic treatment. Neither her history nor the manner in which she presented in therapy gave any indication of potential suicidal behavior. The deceased and the accused jointly attended counseling sessions with Carol Nader, a marriage counselor, in order to improve their communication and restore their marriage after the accused's infidelity was discovered. Their sessions were an up and down affair as the emotional impact of marital infidelity played out between the parties. On the 27th of July, the accused contacted her and informed her that the deceased had committed suicide. She confirmed she was not qualified to clinically diagnose mental conditions such as depressions. However, she had occasions to express concern about the deceased's state of mind, concerns that she could possibly or was possibly suicidal, and requested that the deceased seek further psychological and medical assistance. Now, in my evaluation, which I deal with in detail in my written evaluation, my written judgment, I am satisfied that the evidence of the aforesaid witnesses were reliable and credible, with particular reference to the evidence of Daniels and Thompson as single witnesses. I viewed their testimony with the required caution, with particular reference to that of the evidence of Mr. Daniels, and I am of the view that notwithstanding certain shortcomings, the respective evidence was credible and material in all material respects, and accordingly I accept and find that the truth was told and that I am accepting their evidence. Now, the accused testified in his defense. He gave his evidence in chief with studied precision. He indicated that he and the deceased had argued that Sunday when she caught him sending a message to his mistress. In his attempts to leave the room and go to Jolene, he had to physically move the deceased out of the way, and she kept blocking the door. He did this by placing his hand in her neck and moving her aside. He had also attempted to shake her off when she grabbed at him, resulting in his arm hitting her in the face and nose. She then followed him from room to room, remonstrating with him to return to their room. When at last he found Jolene, the deceased was right behind him, and in order to avoid a confrontation, he returned with her to their room. On the way there, the remonstrations continued. As he shook her off, after she had grabbed him by the shoulders, she fell on the flower bed wall or ledge. On their return to the room, by the time they got into the room, she shouted that she had injured her toe and that it was bleeding. According to him, by this time, the combination of tension between them that weekend, the events of the evening, and the fact that she had now been extremely furious with him, quite frankly, left him exhausted, and he had fallen asleep. It is possible that the argument at that point, in my view, had taken some sort of an intermission. In all probability, he resorted at this stage to his age-old habit of retreating from the deceased and disengaged her by falling asleep. The point of departure, in my view, is that when the deceased woke him up that morning at around 07:06, the drama, as he put it to Miller in an SMS, had in fact continued into its final episode. In my view, and from my evaluation of the evidence, the deceased did not go into the bathroom as the accused would have this court believe. The evidence supports the finding that she remained in the bedroom. The deceased was no doubt furious from the events of earlier. She had been on her cell phone with Jolene, and her fury would have crescendoed at this point. To put it mildly, the exchanges between her and Jolene would have added fuel to the fire. At this stage, the medical evidence support that she had only cut her toe, which had been bleeding on the bed sheet while she had been lying in bed. The only inference that can reasonably be drawn from the events at this stage is that the heated words between the deceased and the accused had escalated once again to a physical confrontation. By all accounts, a scuffle started on the bed, leading the accused to strangle the deceased with his hand. He at some stage struck a punch at the deceased, resulting in the injury on her left eye, and with a pillow on his side of the bed, he had smothered the deceased, leaving her with the facial imprint in the pillow marked B13. The court could see for itself that the blood on the abrasion above her eye indicated the blood stain consistent with the abrasion size and measurement of the abrasion. The mascara of both eyes appears on the pillow, and the blood on the right eyelid, as depicted in the post-mortem photos, came off as a replica on the pillow. The deceased did not just leave her facial imprint in the pillow was being smothered by the accused. She also, in fact, left behind a trail, a story that will speak for her in her absence. So, in summary, I had a number of difficulties with the evidence of the accused. His version of events from the time that the deceased woke him up at 07:06 until when Mark Thompson arrives at the scene around 08:35 was evasive in material respects. This is crucially the time during which the deceased must have lost her life. Various features are so puzzling and highly improbable from the evidence of the accused that I'm left to only draw adverse inferences therefrom. He was unable to give a reasonable explanation, or any explanation at all, as to why his blood was at the scene, more particularly on the bathroom floor next to the deceased. His version does not reasonably explain why, if he had come to the fear that his wife had done something bad in the bathroom and that she was in trouble, he resorted to phoning her at 08:02, but then waits a lengthy 20 minutes to call the hotel reception. Even then, the call by him is limited to simply getting maintenance to open the door. A most peculiar feature throughout the account of events of this morning is that the accused does not call for medical assistance. Not at any stage as matters unfolded does he do that. He does not, furthermore, look at the door handle to see how he can access the bathroom. He does not do the most reasonable and obvious things to do in those circumstances. He does not call for help. He limits this to calling the receptionist for a handyman. He does not go outside the hotel room and engage passing staff, as it is after 8 on a Sunday morning. He doesn't call for anyone else. He doesn't go outside to ask for other guests to come and assist him. Instead, he stays hidden in this room. He does not go outside to go to the window to see if he can get his wife's attention. He doesn't go outside to see if he can gain access through this bathroom window, or simply be able to peep through the window, knock on the window, and if all else fails, break the bathroom window down. After all, according to him, he tried to break the bathroom door down that remained solid like a rock. Even after calling the hotel reception, he remains locked in the bedroom. He waits for a handyman to arrive, however long that may have taken. But he waits there, behind closed doors. In both his interactions with the receptionist and Daniels, he does not alert them of his extreme concerns of his wife in the bathroom, or at the very least that she is in the bathroom. He does not call out to his wife as a final caution that he has someone, a stranger, from the hotel to open the bathroom door. It is highly improbable that Daniels would have tested the door handle when he fiddled the lock. The inference is irresistible. Daniels would have turned on the handle, opened the bathroom door to check that he was successful in getting the door open. And it is most plausible that he stopped when he saw the calves of the person or the guest on the floor. Why the accused did not alert the hotel staff of the fact that his wife is in the bathroom is very simple. He wanted to quarantine the scene by ensuring that an unsuspecting handyman would amount to an alibi to the deceased having committed suicide. When the accused was confronted on various aspects, such as the basic features of the noose around the neck of the deceased, he struggled to answer questions, and he became argumentative and belligerent, often asking questions in answer, or he adapted his version as he went along. He struggled with the narrative that he gave, And there's a reason why he struggled. He struggled with his narrative because the version, as he claims, did simply not happen. His testimony was also fraught with various inconsistencies, and he came across as being economical with the truth, and in my view, he did not make a compelling witness. It must be noted that even when Daniels exited the bathroom and when Lee approaches the scene and engages him whether he should get help, and also when Thompson arrives, he does not ask for medical assistance. I will deal further with this aspect in my conclusion. I will go on with the further experts called by the defense. Dr. Paneri Peter, a forensic psychiatrist, has been called by the accused legal team to conduct a psychological autopsy of the deceased as well as a psychiatric assessment of the accused. Of concern in this matter is that in drafting her psychological autopsy, Paneri Peter drew her findings from a very limited supply of available material, according to her, as she principally consulted persons closely linked to the accused. She also clearly misconstrued some information. Some of her sources were unidentified. They sounded like no more than ghosts, leaving the court to guess their veracity. She also included evidence, in quotation marks, not testified to by the accused himself. The above calls into question the reliability of this witness's evidence, and the court, therefore, cannot accept same. To the extent that she had done a psychiatric assessment of the accused, I accept that until this weekend, the accused did not demonstrate or show in the past a history of violence or physical threat to the deceased. But on his own version, as well as other evidence, this weekend was different, for he did become a physical threat to her. He physically assaulted her. And so that must be seen in context with the view by Dr. Paneri Peter that the accused was not a physical threat, or his behavior was not congruent to spousal intimate homicide. The real contestation between the four pathologists, which were called, two for each side, were that their findings were evenly split, two in favor of hanging and two in favor of suicide. The first to testify was Dr. Kutsia Khan, the state pathologist who had conducted the first autopsy on the deceased. He ran the court through what time he had arrived, what he saw on that day, that the ligature had been removed at that time. He further testified as to the white gown that was loosely draped around the deceased. There was no detectable blood on the back of the door or entrance to the bathroom. The deceased still had a makeup on. He noted a horizontally aligned imprint mark to the front and side of her neck. On the right side of her neck, the mark sloped slightly upwards and had a pale blanched appearance. The mark did not extend all the way across the right side of the neck, stopping just before the ear. There were also linear finger scratch marks immediately under the right lower jaw, as well as on the left front of the neck above the ligature mark. He noted a hematoma. A layperson will understand it as an abrasion to the left eyelid, as well as, he noted a hematoma to the eyelid as well as an abrasion to the supraorbital ridge, suggestive of blunt force trauma by a fist bearing a ring, which was not a feature common in suicides, and instead it was suggestive of a physical altercation. He also noted a small area of blood splatter on the right upper eyelid of the deceased. He noticed bruising to the left knee and left lower leg, a large healing bruise to the upper right leg and thigh, which he estimated to be a few days old, abrasions to the anterior aspects of the toes of both feet with blood staining consistent with having been dragged across a rough surface, a bruise and small laceration on the right hand knuckles, as well as a bruise on the wrist, also indicative of a physical altercation. He also noted fecal soiling between the buttocks of the deceased without any fecal soiling on the bathroom door. Early rigor mortis was evident but not yet complete. Lividity, that is the gravitational settling of blood in the lowest areas of the body on the cessation of circulation, was present over the back and the backs of the legs, while the contact areas of the shoulder blades and buttocks were pale. As lividity set in, he says, in about 30 minutes after death, up to 3 hours. It takes about 3 hours to establish completely. This, he said, would assist him in more or less calculating the time of death, which was dependent on a number of multiple factors. Based on his observations, he could not declare this at the scene to be a death by hanging, and he requested further examination of the scene by the crime scene unit. He also indicated that the accused should be examined for injuries. 2 days later, on the 26th of July, he performed the autopsy in the presence of the investigating officer and Dr. Abrams, the head of the unit. He did not notice a friction abrasion present at the ligature mark, as you would have expected in the case of hanging, and that is something that happens when the cord rubs against the skin and creates a leathery appearance. Also, the horizontal alignment of the mark was not what you would have expected in a hanging, where the mark usually slopes upwards on the sides of the neck to a suspension point. Further, in approximately 80% of hangings, the mark was above the laryngeal prominence, which is quite high up in the neck. There was also no knot imprint indicating where the knot had been against the surface of the skin. It was, in his opinion, that the mark had been applied post-mortem and that the death had been staged to look like a hanging, as the imprint pattern and position was inconsistent with hanging. Rather, it appeared to have been inflicted when the body was in a supine position. None of these factors, to his mind, supported a kneeling type of position of hanging. The scratch marks he had noted were assessed as fingernail marks. In order to confirm his view, he conducted a specialized procedure known as the bloodless field neck dissection, which involves the removal of the brain as well as organs below the level of the sternal notch, allowing for the complete draining of the blood from the neck area. This would ensure that the hemorrhages noted in the neck region were not features that occurred after death, and that it were real hemorrhages. Each layer of skin, muscle, and tissue is then systematically reflected so that the hemorrhage can indicate where force had been applied. He noted a fracture of the thyroid cartilage. The hyoid bone was intact, but showed hemorrhaging, indicative of blunt force having been applied to that region of the neck. He noted hemorrhages to the tissue directly under the scratch marks and above the ligature mark, as well as hemorrhaging to the submandibular gland. Further hemorrhaging in the subcutaneous tissue on the left side of the neck, we had noted 3 additional scratch marks. These hemorrhages significantly is not geographically linked to the ligature mark and did not have any apparent association with the ligature mark, which was on the outside on the skin surface of the deceased. He determined that the injuries to the neck were consistent with manual strangulation, with the hand being used to apply a squeezing type of force to the sides of the neck. Ordinarily, in cases of hanging, hemorrhages present would be directly related to the ligature. That was not the case herein. He noted pallor to the nose tip, the upper and lower lips, as well as a slight deviation of the nose, which he indicated to be consistent with external airway obstruction. For instance, a hand or object being placed over the nose and mouth. This finding was supported by pharyngeal soft tissue hemorrhages and congestion at the base of the tongue. Further, he noted congestion of the internal organs, particular hemorrhages to the surface of the lungs, as well as the surface of the heart, which is consistent with asphyxia. The presence of bruising injuries to the body and face and the fractures to the 3rd to 5th ribs anteriorly was indicative of blunt force trauma. Hemorrhaging in the right chest walls towards the axilla also supported this finding, as did the contusion injuries to the surface of the lungs. He concluded that the injuries to be consistent with a physical altercation and stated that a knee, in all likelihood, would have been placed against the deceased body in order to subdue her, resulting in these fractures. Approximately 100 milliliter of fresh blood was noted in the stomach, as well as altered blood products in the intestines. He opined that due to the injuries to her lungs, she had been coughing up and then ingesting blood, indicating a physical altercation and force before her death. He noted a tangential abrasion to the left shoulder, which indicated was most likely caused by the deceased having been dragged across a rough surface. This looks similar to carpet burn and bruising. The deceased had also had abrasions to her toes, indicative of her being dragged across a rough surface, which abraded the top of the skin. There was also a fresh bruise to the left lower anterior leg and the left anterior and medial knee. His conclusion was that the cause of death was unnatural and consistent with asphyxia due to manual strangulation and external airway obstruction. The injuries indicated that most likely a thumb had been placed on the right side of the neck of the deceased, with the remaining fingers spread over the left side, consistent with manual strangulation and consistent with the hemorrhages found at that place in terms of the bloodless neck dissection which he performed. These images were placed before the court, and the court was able to, through the demonstration of the various pathologists, able to note the injuries so sustained. Dr. Abrams is the chief of the Pol Forensic Services Unit, who exercised oversight of the autopsy. Khan had asked her to attend to the autopsy as he felt that certain indicators did not fit the history of suicide. She concurred with Dr. Khan's findings and stated that the injuries noted were not consistent with death by hanging. More specifically, the injuries to the lungs and the hemorrhages, which were consistent with antemortem injuries, teeth prints in the mouth, which she could not associate with CPR, and the intense congestion in the paropharyngeal area were also suggestive of smothering with a soft object. There was no evidence of long-term vertical suspension. Referring to Dr. Perumal's report, she commented that his autopsy had been performed 5 days after the first, which brought into value its question. She considered the report to be misleading. She also commented on the fact that a number of injuries had not been mentioned in his report, and that the second report would be compromised by the fact that the first autopsy had altered the body, having the effect that Dr. Perumal's findings would be partial or incomplete. The first pathologist to testify on behalf of the defense was Dr. Perumal, a forensic pathologist of some standing, having presented an initial report regarding his findings of the second autopsy, which he performed a few days after the first by the state. He presented the court with a second report, drafted after he had heard the evidence of Dr. Abrams. A first report was handed up as Exhibit B, is placed before the court, and that was his post-mortem report, which was also placed before the court in the bail proceedings. The principal value of his evidence appears to be the concession he made that he could not exclude the possibility of manual strangulation or the existence of a pre-existing injury from a digit or finger underneath the ligature mark, or that the mark under the left eyebrow constituted a separate injury which could have been inflicted with a fist bearing a ring, or possibly a fist bearing a ring. He also conceded that it could not contest the findings of the first autopsy as it related to the soft injuries to the neck. His initial report had failed to mention that a bloodless field neck dissection could not be repeated at a subsequent autopsy, although he conceded that during his testimony. He had also failed to either mention or interpret a number of crucial injuries, such as the scratch marks to the jaw and a great number of other injuries, most of which are normally associated with defensive type injuries. This, in my view, calls into question his non-partisanness, his credibility, and the reliance this court can place on his evidence. The team also called Dr. Loftus. Of the 4 pathologists who testified, he was the only one who did not see the actual body. Instead, he, in my view, attempted to mislead the court to believe that he had conducted a virtual autopsy of the bloodless neck dissection. On his version, his findings were entirely based on the photos taken at the first autopsy, which he himself described as suboptimal. He attempted to, in my view, usurp the court's functions by declaring that it was beyond reasonable doubt that the deceased had committed suicide. Not only is he not qualified to make such an assessment, but the nature of his evidence clearly makes his independence and impartiality questionable. He gave a great length of evidence, and I will conclude it with the following. It has been held by the SCA in Makabela versus the state that a judge must assess on the balance of probabilities by reviewing the whole of the evidence. The appropriate approach is therefore that the judge make findings of primary fact and then consider the expert evidence. I am entitled, therefore, to give preference to one expert theory over another, having considered the matter holistically. Judicial measures of proof is the assessment of probability and not scientific assessment in vacuum. The evidence, when viewed holistically, paints a vivid picture that at 07:06 or shortly thereafter on that Sunday morning, the deceased's sheer indignation at the events which had unfolded in the prior hours would have been inflamed by the furor of exchanges between herself and Jolene. The accused testified that his wife woke him shortly after 7 o'clock, enraged and spewing, open quotations, this is what he said in his testimony, "Look what your whore has sent me." Both the deceased and the accused would have lashed out at each other. It is conceivable that the accused had retorted with his desire to end their marriage. I pause here to state that the evidence in this matter points to the inescapable inference that it was at this point that the wrestling match, which started earlier, had now reignited. Heated exchanges on the bed must have led to physical violence. At this point, taking into account all the evidence, I conclude and infer that the deceased, being on the right of the accused, in all likelihood struck a punch at the deceased whilst on the bed, hitting her left eye and causing the abrasion to the left occipital breach with his ring-bearing fist. I make this conclusion from the evidence of cell phone exchanges between himself and Jolene, which are set out in my written judgment, in which she, which is Jolene, tells him that she had seen him wearing a wedding ring or a ring, and he acknowledged that he did so as a way to throw off the fact that they were having an affair. That was not placed into dispute, and I can accept from that that he was wearing a ring in all probability at the time that the deceased had died. At some point during the wrestling match, the accused manually strangled the deceased. The evidence clearly reveals that the accused manually strangled the deceased and smothered her with a pillow and exerted pressure on her chest, resulting in her ribs being broken. Possibly it was at this point that the accused sustained a bleeding defensive wound to his finger. For how long he remained in this position is uncertain. But when he got up, he devised a plan to set a scene telling a story of the deceased ending her own life. The accused must have dragged her from the bedroom, across the carpeting, enter the bathroom, causing the tangential injury to her left arm and shoulder, the abrasions to her toes, and leaving a fecal smear stain drag mark on the bathroom floor as you enter. He could not lift her up unaided to wind the cord around her neck, as she would have been too heavy, so he would have had to lay her flat on the floor, wind the cord around her neck, retreated to the bedroom, and locked the bathroom. I pause here to add that this is not the cord which at that point have caused the indentation. The indentation I leave to deal with a little bit later. The plan was almost complete. He only needed to cover his tracks, so he called her cell phone at 0802 and at 0822 calmly called reception requesting assistance with a locked door. Thereafter, the innocent bystanders started coming in. First, Mr. Daniels to open the door and make the horrifying discovery, Lee offering assistance, and then Mark Thompson, who desperately attempted to do what he could and thereafter attempted to comfort the accused, followed by others. At some point after her discovery, in inverted commas, he had attempted to dress her in her hotel robe, but with her body being unwieldy, he could only manage to slip her arms into the sleeves. In his haste, he did not notice that the robe was inside out and that the belt was still on the bed. As regards the topic of staging, I quote playwright and author George Bernard Shaw, 1956 to 1950. He wrote, "In order to fully realize how bad a popular play can be, it is necessary to see it twice. The evidence indicates that the accused had set a scene to tell the story that his wife had committed suicide. He staged her death as a play, setting in motion various actors as his alibis. Phone records at 0802 and at 0822, the hotel receptionist, the handyman, and the extras followed. It was after Daniels exited from the stage that he revisited the scene with a change of the stage setting in an attempt to improve the play. He changed the cord at the back of the door to be more consistent with her having been in a crouched position. He donned the rope around his wife's dead body and changed the cord from which she had allegedly hanged herself, believing, as he must have, that his accounts of events would triumph over that of a handyman. The accused, in his words, were used to and good at throwing off his guilty tracks. Ducking and diving the truth and concealing his mischiefs is what he said he was good at. I see this staging as a further extension of that skills. The views of the pathologists were diametrically opposed as to whether the ligature had been applied pre or post-mortem, and the evidence presented in this regard was substantial. The court does not have to determine at which point during the staging process the accused affected the ligature imprint on the deceased. But affected he did. The fact that the accused had by this time already applied the fatal force to the deceased makes the determination for the purposes of this judgment unnecessary. The ligature mark was superficial, and there was no underlying associated injuries which could have resulted in her death or could have contributed thereto. By the time the indentation was created, the deceased was, at the very least, fatally wounded, and death was inevitable. For the sake of completion, it must be stated that the evidence through the testimonies of various witnesses before the court illustrates that the deceased conducted herself with a tenacious pursuit of her husband and their life together. She, by all accounts, was relentless in this regard. She was full of life. Notwithstanding various occasions, particularly during the Speed weekend, where she became aware at various stages of the continued affair, she nonetheless remained resilient in her endeavors. For example, a cell phone exchange between herself and the accused on the Saturday morning shows that she was alive to the fact that her husband's affair was not over. She stated at 12 o'clock with 25 seconds p.m., open quotations, thought it was finished. The accused responds at the same time, 12 o'clock and 37 seconds p.m. We are finished. Notwithstanding these exchanges and evident acrimony around that, they go to have lunch at Rust and Vrede at Stellenbosch together. Hours before the gala dinner, the deceased has sent the accused a message. You are a devious fucking bastard. They proceed nonetheless to attend the gala dinner together, and they leave together. I do not infer from the evidence that her discovery that the deceased sent a message to Jolene was a revealing or cathartic moment, for she had by that time already known of the accused's infidelity and underhandedness. She was not apoplectic, as the accused described her at the moment of catching him in the bathroom in flagrante delicto. Though she was clearly furious and agitated, she was no means disabled by her fury. She continued the fortitude to commit to her goals, that keeping her husband in her company and saving their marriage was still her priority. This is confirmed by the evidence of Farah Amir Mia and Brandon Miller, who were in the room with Jolene when the deceased fetched the accused. This she exhibits through following him around on the Spear estate until he returns with her to their room. Quite clearly, her actions until her moment of death were consistent in assuring a life together for them. The deceased and the accused, from their cell phone exchanges and other independent evidence, illustrates that their fights would normally seesaw between extreme anger, which would soon turn into loving and reconciled statements. It was not unusual for the talk of divorce or termination of their marriage to enter into the fray of their arguments. Notwithstanding that, it had always returned to rational talks about their marriage and their future. In fact, the deceased had a standing arrangement to the days after that Sunday see her psychologist and marriage counselor. The suggestion by the accused that his words at 07:06 or shortly thereafter to the effect that he was finished with the marriage would have altered the deceased's regular reaction and fortitude which she had always exhibited in the past. It is highly improbable that with those words and after her message to Jolene, that she would have turned on her heels to the bathroom, locked the door, and hang herself from the towel hook. It must be added that the evidence proves that the deceased, beyond reasonable doubt, did not commit suicide, nor does it prove that she had taken her own life. The court accepts from the evidence that the accused, beyond reasonable doubt, murdered the deceased. Mr. Rohde, you've got to stand now. This court is satisfied, taking into account the evidence before it, that the state had proven its case beyond reasonable doubt, and that your version is not reasonably possibly true, and it is accordingly rejected. The court finds that you murdered the deceased and then staged the scene to give the impression of a suicide. Furthermore, in light of the nature of the injuries, the manner and the cause of death, the court finds that you had the direct intention to kill the deceased. I therefore find you guilty on both charges, on both counts as charged. Thank you. Thank you. Can I be addressed on sentence in a few days? How about Wednesday? What would be Wednesday's date, Kurt? What is Wednesday's date? 15th. Yeah? The court will stand down for 10 minutes if that will assist you. In the meantime, bail is withdrawn. The accused shall be retained in custody and remanded in custody. Court will return in 10 minutes. Thank you.
15th of this month, which is if I'm not mistaken.
Sorry, what's the date? It's the date on Wednesday? The 14th.
I'm sorry, the 14th, which is just a day less than a week from now. My lady, in terms of the sentencing process, we will be wanting to place evidence of a mitigating nature before the court. This will involve, hopefully, the birthday evidence from friends, family. I will most certainly be wanting to call expert witnesses in that regard. I have in mind, for example, although I haven't taken instructions on this, calling Dr. Kevin Stoloff as a witness, who's known to the court, calling Dr. Daniele Peter in terms of her assessment. And my lady, the bottom line is the period is too short to the 14th for us. And I beg the leave of the court to extend that by a further week to the 21st. And that in itself will be very, very tight for us. The other aspect that I want to address the court on is the question of bail, and I request that his bail he be granted bail. As I understand the law, once convicted, the bail automatically falls away that was granted. The court does have, as I understand it, a bail bond to the value of 100,000 rand, which has been his bail up to now. And I request that this bail be extended at least until, I think I said the 21st of November. And my lady, if I could just address the court on that aspect. Obviously, it is premature at this stage for me to go into any depth or discussions of any nature whatsoever, really, regarding applications for leave to appeal. I have been indicated that I will be getting instructions that it is the intention of the accused to apply to this court for leave to appeal, and it is my respectful submission, without wanting to preempt or anticipate anything, that if the application for leave to appeal is brought, will essentially be brought on the basis of two aspects.
No, we're not going to argue that now. We don't deal with appeals in piecemeal basis. I came back into court to address arrangements regarding sentence, and I will entertain to the extent that you wish to ask this court for an extension of bail. No more. No more.
And what I'm wanting to say is that the crucial question that arises when determining bail is, does the change in circumstances alter the position with regard to whether he should be granted bail or not? And I do submit that the perception of the accused that he has a reasonable prospect of success on appeal is...
That is not the test. That is not the test. That is not the test now. Is there anything else you'd like to address?
Yes, my lady. I would like to do the following. I would like to point out to you that if anything, there is anything to go by in terms of the bail application, that the track record of the accused is absolutely 100% exemplary. Throughout the period since he's been granted bail in this matter, he has never failed once to report, to sign in, to get permission, or to come to court, with the sole exception of February this year, when he was hospitalized with a major depressive episode that was confirmed by Dr. Stoloff in testimony. An inquiry was held by the court in that regard, and the explanation was accepted. So essentially, he has been a totally compliant accused person out on bail. He has immovable property, although heavily mortgaged, in Plettenberg Bay at the moment. That is the only immovable property which he owns. The house, which was owned and registered in the name of the deceased in Johannesburg, Bryanston, was sold, and the money there is in the estate of the deceased. It's been withheld from the accused here. His family circumstances are very conducive to not being a flight risk. Without going into personal details regarding the situation there, I can tell you that he has a daughter who is in the second year of university, and he has two twin daughters who are at the moment writing their matric exams. I believe, in fact, that they started writing their exams today, if I'm not mistaken. His parents live with him in, as I understand it, or when I last heard, in the home in Plettenberg Bay, and they assist him with the children. So, with respect, I don't believe that there is any conceivable possibility of him constituting a flight risk. Apart from anything else, his passports are and remain and have been, since he handed them involuntarily, in the possession of the police. So my request is that at this stage, pending the sentencing process on the 21st of November, the bail be extended. Thank you.
Thank you. Would you like to add anything?
Yes, my lady, I'm going to oppose personally that we stated with the found guilty of very serious charges. Minimum sentence is applicable. There has not been brought proper application for leave to appeal, which this court.
No, that isn't even something we will go to now. Okay, Karen.
And lastly, the date, I would submit next Wednesday is the time. Both the experts indicated by the defense.
I don't think you can say that. You can't speak on their behalf how much time they need. They're entitled to ask for more time. You're not required to comment on that. You're required to comment on whether you oppose bail or not, which you do. Okay. Thank you. Anything you'd like to say now?
No, maybe I don't think there's anything more.
Thank you. Thank you. An application was brought for the extension of bail, or rather reinstatement of bail for the accused on the same conditions, I assume, as previously instated. I make pertinently the following point. The status of the accused is now changed. The court has convicted Mr. Rohde. He is now a convicted criminal. The presumption of innocence is no more. The bail which he was previously granted was bail extended on that presumption of innocence. I will, in the interest of justice, consider other aspects. I may wish to add also that it's not true that he was 100% compliant with his bail conditions. I did not pronounce in February as to whether Mr. Rohde's non-attendance at court was justifiable or not. You would recall, and I say this on record, that the letter by Dr. Stoloff indicated that when the investigating officer, at my instance, went to Crescent Clinic to collect Mr. Rohde to attend at court, he wanted a court order and refused. When the court adjourned thereafter, Mr. Mihalik handed up a letter by Dr. Stoloff, which is part of the exhibits. In that letter, Dr. Stoloff does not indicate that Mr. Rohde was unable to come to court with the investigating officers, as I had requested. He indicated that Mr. Rohde was unwilling. And this shows intention on the part of Mr. Rohde. It's not for Mr. Stoloff to shield, Dr. Stoloff to shield Mr. Rohde in circumstances where he had gone into hospital 2 days or on the eve of the trial recommencing. And just to add to that, I see it in a dim light that notwithstanding the fact that Dr. Stoloff said in his letter that Mr. Rohde needed some 6 weeks or more reviewable for treatment, after I took the matter on and indicated that the sections of the Criminal Procedure Act applies where it is mandatory in the circumstances where it was before the court under oath that Mr. Rohde was unable to appreciate the proceedings, that I was required to send him for observation. Very quickly at that stage, Mr. Rohde made a recovery. In fact, he left Crescent Clinic even before the time which I provided him with, and he made a very quick recovery. In fact, so quick, you could make the decision of terminating his legal team, which shows the capacity to make such decisions. That was recorded in the report by Dr. Stoloff some days after Mr. Rohde apparently had severe, major depressive episodes of depression. So it is not correct that he complied with all his conditions. But in any event, we are on a new turf now. Mr. Rohde has been convicted. I've considered the other interests that you have indicated, and I'm not persuaded that the interest of justice weighs in favor of Mr. Rohde being granted bail. This is a very, very serious offense. The minimum sentence legislation applies. And I think it's inconceivable that in these circumstances and the facts before me and the facts of this case and the gravity of these offenses, this very, very grave nature of it, compounds the fact and militates against it granting Mr. Rohde an extension of his bail. That deals with that. The matter is postponed till 21st of November for pre-sentencing. Mr. Rohde, I've executed your warrant. You'll be returned on that day. You'll be held in custody and you are herewith remanded in custody. Thank you. Court's adjourned.
All right.